which forum would adjudicate upon and which forum would be the suitable forum and constitutionally the only permissible forum where this debate can take place.
Because even after 377, my lord, there is a stigma. If two people walk hand in hand in a park, my lord, or in a hotel or in a mall, they are still stigmatized in public. That stigma will only go after the imprimatur of this court that they are entitled to get married, and the state shall recognize it. And once the state recognizes it, it can also be registered. And that will be full and final assimilation of this minuscule group, my lord, into
smaller areas, yes. But there is this acceptance which is evolving. So, in this evolving consensus, the court is also playing a dialogical role to create that consensus and move towards a more equal future. While being conscious of our own limitations, which we can't deny in the legislative arena.
But marriage is not only a question of dignity, as if that were not enough. It is also a bouquet of rights that LGBTQ people are being denied post-Johar. Right? Those rights are simple things. Bank account, life insurance, medical insurance. I, for instance, frankly...
Parental accommodation.
Freedom of choosing sexual orientation. No objection, my lord, cannot have any objection. That's my lord's judgment. Freedom of privacy. No objection. Act take care. Discrimination, there cannot be. The Act takes care. I'll my lord show to your lordship. The limited question is conferment of a socio-legal status and whether that can be done by judicial adjudication.
If this is the thread of the Constitution, equality, fraternity, justice to all, today we are a part of the all. The only thing which was stumbling, my lord, was that criminality. That is now gone.
Therefore, the problem is that anything short of that, if it is a civil union, so this correspondence will now start, my lord, with insurance company, with banks, with hospitals, with wills, with estate duties, with anything that is prerequisite to being able to live a life outside the home, including buying that home.
In the event that your lordship holds marriage to be this way or that way, not creating an empty shell called the word MARRIAGE, it has to have some consequential benefits. Marriage, in any case now, you can have a live-in. You need not even call it marriage. It is because of the consequential benefit.
The only biological man means biological man. It's not a question of notion.
Yes, of course it is. There is no absolute concept of a man or an absolute concept of a woman at all. That's the argument in a broader.
Either you take it as a whole or don't take it at all. I'm not averse to either. But if you do it piecemeal, it will create more problems for that unity, for that union, for those two people, whether they are women.
So to say that this is a matter for Parliament is not just unknown to the Indian parliamentary form, which is constrained by the Constitution, but in fact seeks to impose a British parliamentary model, which has no place in this jurisdiction.
And how much further do we have to go? This is just any other case at the end of the day. It may mean a lot for all of us personally. It may mean a lot for many other people in the community as well. But at the end of the day, my lords are discussing a list which is before my lords.
The right of judicial review is part of the basic structure of this constitution, of which this basic structure doctrine we have now celebrated 5 decades. Those 5 decades belong to LGBTQ people also.
I have something more to add, my lord. I adopt what the learned senior has said. Lord, the subject your lordships are dealing with virtually, my lord, creation of a socio-legal system, socio-legal relationship of marriage, which, my lord, I'll come to, my lord, my preliminary objection. would be, my lord, the domain of the competent legislature. When the subject is in the concurrent list, we cannot rule out the possibility of one state agreeing to it, another state legislating in favor of, another state legislative against it. So therefore, in absence of the states being not joined, my lord, the petition would not be maintainable. That's one of my preliminary objections. We didn't have an occasion, my lord, thereafter matter was never heard in merits, to raise the preliminary objection whether this court can at all go into this question, or it would be essentially for the parliament, my lord, to go into that question. Second, my lord, we also, my lord, would like to point out what would be the repercussions, my lord, if the court were to take it upon itself, my lord, in the judicial forum to take this call. The sum and substance of my application would be, if I were to say in one line, the debate which is to happen with respect to the subject matter of creating, conferring a sanctity, legal recognition of a socio-legal institution, should that be the forum of this honorable court or the forum of the forum of the parliament? First of all, I'm making it very clear. My preliminary objections are not my objections on the merits. If merits were to be gone into, there are separate set of arguments. These are not, my lord, these are only for deciding which forum would adjudicate upon and which forum would be the suitable forum and constitutionally the only permissible forum where this debate can take place. So by the very nature of the objection, it must, in my respectful submission, be heard first. While arguing my preliminary objection, I'll not raise any submissions on the merits of the case. I'm, my lord, very, very clear about it. And, my lord, therefore, my lord, your lordship,
solicitor, we'll reserve, whether to hear you on the preliminary objection at this stage after they have opened up, just for about 15 to 20
minutes.
Then,
then your lordships may do one thing, my lord. That's the another request. My lord, let them give, my lord, their, my lord, whatever submissions they want, overview, confined to, my lord, what my preliminary objection is. My lord, I can't be
certainly not. We'll not do anything.
Open my case.
My lord, I'm sorry, my lord. My lord, I'm sorry.
I'm sorry, Mr. Solicitor. We are in charge. We will be here, Mr.
I'm sorry, my lord. Kindly last minute, my lord, last.
Mr. Solicitor, we'll hear you later.
Yeah.
Yes, Mr.
Lord,
Rohatgi.
only a minute, my lord. Only a minute.
No.
My lord, your lordships may give me a minute.
Dictate to us how we will conduct the proceedings.
No. I'm not, my lord. I am earnestly
I'm not allowed that
requesting.
in my court.
My lord, I am earnestly request. I would never do that. Your lordship knows, my lord.
Yes.
My lord, this is a matter, my lord, too sensitive an issue,
Of
where, my lord,
yeah.
your lordships would examine the preliminary submissions and, my lord, then give me some time. We may have to consider what would be the stand of the government,
Sir.
my lord, in further participation in this debate.
So trust us to have a broader perspective of everything.
My lord, I fully trust, my lord. There is no question
Therefore,
of
we are
lack
just-
of trust.
We want to understand from them what they want to argue.
My lord, then, my lord, your lordships may give me time, my lord, to consider to what extent the government would like to participate in this.
Anything but adjournment. And I think anything but an adjournment.
No, I understand, my lord, your lordship's anxiety, my lord, I understand. I share that.
So, sir, are you saying that you don't want to participate? No,
But,
Very
my lord,
strange
I am
way to
only
to
saying,
participate. It's a prerogative you have.
my lord, I'll not
But
go
they
that
can
far,
do
my lord.
No, Mr. Listen, that, let me say that. It look nice. When you say that we will see whether we participate or not.
No, my lord, I'll take instructions. I didn't say I'll not participate.
Instructions are here.
My lord, the instructions on the question whether which forum should debate and discuss this subject.
That's a very important.
Lord, this is not an issue which can be debated, my lord, by 5 individuals very learned on that side, 5 individuals on this side, 5 very brilliant minds on the court, no doubt about it. None of us knows what are the views of, my lord, a farmer in South India, a businessman in, my lord, Northeast. Lord, these will have to be, my lord, this will have social and other ramifications, my lord.
Yes, of course. We'll consider that. We'll certainly have.
In a very, very narrow conspectus. My lord, we are persons, my lord, who are of the same sex. We have, my lord, according to us, the same rights under the Constitution as the heterosexual group of the society. your lordships have held so, I don't need to reinvent the wheel. That we have exactly the same rights as our brethren of the heterosexual group of society, which is the majority. We are a minority. The only stumbling block on our equal rights, equal opportunities, equal dignity, equal fraternity was, my lord, 377. By virtue of 377, our actions were subject to criminality. Because it was criminality, my lord, it could not be equal in all measures of the heterosexual group. Criminality is now gone. The unnatural part or the order of nature under 377 is now effaced from our statute book. And therefore, our rights being equal in all forms, which are, my lord, reflected from Puttuswamy, Navtej, my lord, the judgments of this court on the right to marry a person of your own choice, Shafeen and all that, which I will show. If our rights are identical as held by the state, then we want to enjoy the full panoply of our rights under 14, 15, 19 and 21 to lead a dignified life, not mere existence like your lordship said in Francis Corali Bulletin 40 years ago. To lead a life to our fullest extent with dignity, privacy in our home, and, my lord, without taint or stigma in public places. And therefore, we cherish and desire the same institution between two people as is available to the others, which is, my lord, the concept of marriage, the concept of family, because marriage and family is respected in our society. We don't, my lord, today, my lord, laws have now, my lord, progressed. In the Domestic Violence Act, even live-ins, my lord, are allowed. That is recognized by the court. Your lordship recognize it by even giving, my lord, property, money, inheritance, etc. So there is no reason why, once our rights are identical and same as held by your lordships, my lord. And that has been the development, my lord, in the US and other nations. I have made a one-page chart which I will show to your lordship. Therefore, my lord, we seek a declaration. Because we have to be concrete. What do we want from the court? We seek a declaration that we have a right to, my lord, get married. That right, my lord, will be recognized by the state and would be registrable under the Special Marriage Act. Because even after 377, my lord, there is a stigma. If two people walk hand in hand in a park, my lord, or in a hotel or in a mall, they are still stigmatized in public. That stigma will only go after the imprimatur of this court that they are entitled to get married, and the state shall recognize it. And once the state recognizes it, it can also be registered. And that will be full and final assimilation of this minuscule group, my lord, into. I want to say, my lord, that your lordships will broadly read spouse in place of man and women or husband and wife. And that is it. And if I may show, my lord, a classic example of the definition of marriage in Black's dictionary, which I will show to your lordship. In 1968, said, my lord, it's a union of a man and woman. But when the definition came in 2019, it says, my lord, a union of two persons.
Concept of marriage is changing.
So concept of marriage has changed over last 100, 200 years. We had concepts of, my lord, group marriages. We had very different concepts. We had concepts of child marriage. We had concepts of, my lord, temporary marriages. We had concept that, my lord, prior to the Hindu Code Bill introduced by Pandit Nehru, my lord, in 1950, a person could marry any number of times. That, my lord, also changed. Hindu Code Bill, my lord, was not accepted. There are a lot of protests to this new avatar of the Hindu Marriage Act. It was not accepted. And Dr. Ambedkar had to resign. Then came the evolution of Hindu Marriage Act. Now in Hindu Marriage Act itself, my lord, in 2005, the rights which were restricted of women, starting from the Women's Right to Inheritance Property Act in 1937, all that has now changed, my lord. And full rights are available in 2005. So, my lord, Constitution is a living document. The preamble says, my lord, equality, fraternity. And I will read passages of, my lord, the Chief Justice, my lord, judgment, my lord, in Navtej, in Puttuswamy, in Shafeen, in Deepika, and Justice Kaul, my lord, also referring to it. This is the thread. If this is the thread of the Constitution, equality, fraternity, justice to all, today we are a part of the all. The only thing which was stumbling, my lord, was that criminality. That is now gone.
So you're not going into the broader issue of personal law and other things, we take it. Right?
No, my lord, I am not.
Right.
And I am not also touching any personal law of Muslims, etc., my lord. Somebody may raise an issue, I am not. Hindu Marriage Act, yes, but basic first will be Special Marriage Act. And your lordship knows, my lord, a legislative tool in the Indian legislative devices has always been that a definition clause always starts with, my lord, your lordships are aware, unless the context otherwise requires. That is the elasticity given to every legislation, more or less, in this country by Parliament, that you have to, my lord, adopt or adapt to 20, 30, 50, 70 years later. Can't keep changing the law. Can't keep changing definitions. So you have, unless the context otherwise requires. So if the context requires that a man and a woman or a husband and wife to be treated as persons or spouses, your lordship will do it by an interpretation. My lord, our lives are passing by. We are getting older. We also want to have the respectability of a marriage, respectability of a couple. What is the point of saying that only criminality in your bedroom is removed? But, my lord, when you go out, there is a passage of Justice Chandrachud, my lord, in one of those judgments, that what matters is what happens in a public space. What is the concrete position? If today, my lord, what is the position? All right, 377 is gone. But if these people, call them queer, call them strange, people call them all different names. If they were to go to different places, people look at them. Look, they are going this way, they are going that way, they are doing this, they are doing that. That, my lord, that is a restriction or an infringement of my right, which is Article 21, to, my lord, live with dignity, freedom, privacy, full expression of thought under 19(1)(a), no discrimination under 14, and, my lord, in 15, as the lordship knows, there will be no discrimination only on the ground of sex, caste, creed, etc. My lord, sorry to say that NALSA said that give them a reservation. Years ago, nothing is done. Years ago. Your lordship judgment, my lord, in Navtej, give full publicity. Today I read in the Indian Express. Today, your lordship judgment says give full publicity. People must know that it's not a criminal offense. Don't look at them with this stigma. My lord, years ago that judgment was delivered. Nothing done. And the three ministries today say, we have not done anything and we are not supposed to do anything. If this is the state of affairs of legislative, my lord, interference or legislative response to judgments of this court, I have no choice but to knock at the doors of this court. Parameters.
So in other words, like two alternate lines of approach for the court. Assuming you are right that you're entitled to a declaration.
Yes.
I mean, assuming, of course, we have to hear the other side. Assuming you are right that there should be a declaration of the right to marry,
Yeah.
then there are two courses of action according to you. Either the court then finds a legislative void in that Parliament has not legislated expressly to recognize the right of marry. And therefore, finding a legislative void, you supplant that deficiency so long as Parliament enacts law. The other option is to locate the modalities for implementing that declaration in existing law.
Correct. So, my lord, my short, most respectful answer would be, if you take Vishakha as an example, in Vishakha, there was no law at all. The court laid down a set of rules which was to work as interim law, if I may use that phrase, interim law or rules and regulations under Article 141 till, my lord, Parliament acts. Parliament then acted. But the void was filled up in Vishakha in this form. I am saying that in our case, because of our past history, Vishakha had no history. There were no cases before that. We have past history of Puttu Swami, Navtej, all these cases, Shafin, etc., etc. In that past history, all I am requesting is the second step, and the second step to be implemented not by the Vishakha rules, but by virtue of the law already available by, my lord, a process of legislative interpretation. That's how I would.
Now that we have understood, broadly, we've understood the canvas of the matter, then we can really, at least at this stage, we are not ruling it out for the future, we can steer clear of personal law in that case. So if we steer clear of personal law, then perhaps we make the first, I mean, that is one possible option as you opened it up.
As far as two of us are concerned, we are not leading. There may be other people.
My lord, there are concerns about the Hindu marriage.
Because it may not be necessary for the court then to get into more vexed issues pertaining to personal law.
Codified.
Yes, my lords, Hindu marriage, the
It's
Hindu Marriage
codified.
Act,
So perhaps you can all address us on this aspect. That's why when we began, we
Can I take 2 minutes?
just a minute.
5 minutes.
just a minute.
The possibility.
The states must be heard. It's a constitutional issue.
Dr. Guruswamy?
My lords, thank you. My lord, the Chief Justice may recognize, my lords, that the Hindu Marriage Act is not an issue necessarily of personal law. It is statutory law. And we will demonstrate that. The terms of the Constitution, the reform of the Hindu Marriage Act has always been in the context of statutory law. So, my lords, to that extent and that extent only, in the context of statutory law and making statutory law workable, because my lords will know, my lords, that the origin of the Hindu Marriage Act, the Hindu Code, did something that was not permitted in sacramental Hindu law, which is intercaste marriage, Sagotra marriage, divorce,
Inheritance to
Dr.
inheritance.
Guruswamy, but there's also Dr. Guruswamy, there may be some amount of sage wisdom in also going about our interpretative task in incremental manners, because otherwise, do we then confine ourselves only to the Hindu Marriage Act? Then what about the Parsi Marriage Act? What about the Muslim law? What about the Jews? What about the Buddhists? A lot of other communities. Therefore, perhaps one option for the court, because the Constitution itself and the law is itself evolving. So, and the court has to be mindful of the fact that we are doing by process of interpretation what you're calling upon us to do. So it may be, there may be some element
Two
of
minutes for the
some element of judicial
if I may-
discretion and perhaps going incrementally, covering a canvas for the present, which would substantially then, assuming that even there you are right, because you have to hear the other side, confine yourself to this incremental canvas and then allow society to evolve, allow Parliament's perceptions to evolve over a period of time, because Parliament is also responding to the evolution of society over a period of
One
time.
is the canvas after Ms. Guruswamy is finished. I want just 3 or 4 minutes. We finished?
Yeah, go
But it's only 3 or 4 because learned friend is given, my learned friend is given.
Because we can't deny the fact.
On canvas.
We can't deny the fact that there is undoubtedly the legislative element also involved, which is why we are saying states, the parliament, what the
My
solicitor said.
respectful submission.
Having regard to that, we
Hello?
need to balance out various facets. So this might be perhaps one way forward.
That's the only thing I'll say to this. Is,
So we don't have to decide everything to decide something in this case.
no, my lords, I follow. The only thing
There are,
I'll say to,
Guruswamy,
yes, my lords.
one is the channel pointed out by Mr. Rohatgi in a restrictive sense that only construe the Special Marriage Act. If it founds favor with us, it will give us status of marriage. If it not, he rightly said you are out. Therefore, whether other issues at all arise or don't arise will depend on how we interpret this aspect. Other
Lord,
issues
if I
may
may-
survive for another day or may not survive for the time being for another day, depending on what view we take on this core issue. And in the wisdom, as the Chief Justice said, sometimes incremental changes in issues of social and society ramifications are possibly a better course. There is a time for everything. There is time for some things to come. Therefore, what was being suggested was, can we, for the time being, confine it only to this limited issue? Don't step into, let me complete. Don't step into personal law issues under different religious norms. Don't get into any of those issues. But only say that, can the Special Marriage Act be interpreted in a manner by reading into it a general, a gender-neutral situation. Period.
Can I say?
Not
And
that
perhaps
as far
you
as
can then
maybe
help us,
the
you can
question
assist us, you
left
can assist
open.
us, and we'll ask the solicitor also to assist us on how we can sort of develop the notion of a civil union,
Yes.
which really finds recognition in our statute, namely the Special Marriage Act. See, because now, for instance, I'm sure you wouldn't also deny the fact that between the time that Navtej was delivered and today, our society has found much greater acceptance, say, of same-sex relationships. For the last 5 years that we have seen it unfold, there's
Definitely.
been, and that's very positive because there you find that there is a greater acceptance in our universities. And by the way, our universities don't consist of only urban kids; they all come
Yes.
from the
Yes, of course.
smaller
all over the country.
areas. Yes,
Yes.
but there is this acceptance which is evolving. So in this evolving consensus, the court is also playing a dialogical role to
Yes.
create that consensus and move towards a more equal future.
My lord,
It's for
While
the-
being conscious of our own limitations, which
Yes,
we can't
madam.
deny
I
in
follow.
the legislative arena.
I follow. The only request I would make is that the question may be left open to be adjudicated. at a
Obviously,
future
we're not going to
time.
reject what we don't.
Yes,
We
madam.
can always
But we-
confine our
Yes.
canvas and then not reject.
Yes.
Obviously not.
Yes. And my
That is not
second
necessary for the court to do at all.
point is simply this, that the second point is simply this, that marriage is not only, as if that were not
But leave
enough.
broader and broader issues for an evolving future.
Yes, but marriage is not only a question of dignity, as if that were not enough. It is also a bouquet of rights that LGBTQ people are being denied post-Johar. Right? Those rights are simple things. Bank account, life insurance, medical insurance. I, for instance, frankly,
Rental accommodation.
I cannot buy SCBA medical insurance.
Citizenship.
I'm a member of the SCBA bar. I cannot buy my family medical insurance from the SCBA. So this is the reality of how rights are exercised. Rights are exercised when you are able to protect your relationships. One facet of that right is a constitutional value of dignity, equality, fraternity. The other facet of that rights is the day-to-day business of life. And the day-to-day business of life is all of these things. Now, when we look at law in India, and all common law is premised like this, that most rights flow from this notion of blood relationship, i.e. either being born into the family or being married. That is the problem, my lords. And so, therefore, short of full marriage, whether my lords find that under the Special Marriage Act or be that as it may, short of full marriage, it will mean, if it's short of that, it will mean that subsequently, not just Mr. Rohatgi, Mr. Kirpal, me, we will keep coming back to court to have to litigate individual issues of discrimination. I am not able to nominate my partner for life insurance. Now, these are not theoretical issues. This is our life. Right? So therefore we say marriage, because that is the notion, not only for society, but that is the notion that the legal framework, which is premised on common law, understand and takes within its fold. So therefore, my lords, respectfully, therefore the problem is that anything short of that, if it is a civil union, so this correspondence will now start, my lord, with insurance company, with banks, with hospitals, with wills, with estate duties, with anything that is prerequisite to being able to live a life outside the home, including buying that home.
Well, let's,
So the statement,
there are
and so there are
things.
folds here.
Marriage and persons. Same sex is a slight misnomer. The correct word is person, not same sex. I'll just take 3 or 4 minutes first. Marriage largely, my learned friend is covered. Whereas there is 2 categories of consequences. These are consequential issues she is raising. One is the minor or major secular consequences of marriage. Your lordship is not in this matter. In the event that your lordship holds marriage to be this way or that way, not creating an empty shell called the word marriage. It has to have some consequential benefits. Marriage, in any case, now you can have a live-in. You need not even call it marriage. it is because of the consequential benefit. So your lordships may need, this is entirely a lordship discretion. I understand it's a great advance in law if your lordship even were to interpret same person marriage as a marriage. I'm not at all diluting or reducing that. But your lordships, according to me, even in this more limited canvas, must consider traveling a little ahead. One category is what my learned friend has said. These are secular incidents of daily life. They involve nothing beyond that. And your lordships can have a reasonable listing. Now, there are larger issues which your lordship will explicitly keep open. I would say that even those can be covered by marriage, but possibly, we are too early to start doing that. There is succession law, certain aspects. There is adoption law, certain aspects. There is certain other things. We are not at all giving it up or lessening it. But your lordships in this, the crucial word which fell from the Chief Justice is incremental. I always believe that your lordships in such matters is like a rubber band. Your lordship expands incrementally slightly. You stretch the rubber band too much, your lordship is pushing pressure that the rubber band will break. Because that slowly movements is on the societal view of the rubber band. Now, adoption, according to me, is crucial. Is crucial. There may be some non-adoption issues which your lordship may not consider crucial. I'm not able to, in fact, itemize. But your lordship will guard against holding on the left hand, in the event your lordship so holds, that marriage of same persons is valid, and on the right hand, make it an empty shell.
I must not make it, my lord. I in fact achieved an impossible thing today, my lord, making my lord the Chief Justice angry. Few people have done in past, but I am not in very excellent company, my lord. I must confess that. Lord, first of all, the question really, my lord, we are misdirecting the question. The question is not right of equality, right of dignity, or right of privacy of persons who belong to LGBTQ community. That is first. The question is right of conferment of a socio-legal status and whether that can be done by judicial adjudication. But so far as, my lord, kindly give me 15 minutes, my lord, to give the chronological events. Lord, there was no law governing, my lord, the rights and other rights and other, my lord, immunities to the LGBTQ community, my lord. Nalsar judgment came, thereafter Navtej Johar came. Lord, now kindly see, my lord, my affidavit. I am not on the merits of the matter, my lord. On merits, I have different arguments. Please see the Transgender Act. Most of the arguments, my lord, are covered. There is no legal lacuna. There is a statutory framework and there is a conscious omission by the statute. My lord, in my IA, my lord, I have annexed the small act. My lord, this is 2019 Act after Navtej Johar.
I'm not talking about transgenders here. Lord,
So
my
your lordship
case is
have
not on transgenders. My case is not on transgenders.
Lord, my learned friend may allow me now. My lord, I never interrupted him.
But then, sir, I am on my legs. I want to finish my thing.
Lord, he has not seen the act. Otherwise, he would not have said this.
Wait. We have permitted your side to.
I know that.
Just open and
to
give
get a
us a
perspective.
No, I am not saying no, Lord.
You shouldn't plead violation of
No,
article.
I'm not complaining. I want to get on with
You
it.
also get a right to set forth the contours, and we may be able to put some.
I appreciate. No, I'm not.
How we are limiting what we propose to limit. So that
Lordship.
then, unless you know what he has to say, how can
Lordship,
Lord, this is, of course, my lord, subject to my first respectful submission about the maintainability. But, my lord, just I'm assisting your lordships on this. Lord, this comes after your lordship's judgment of 2017, Navtej Johar judgment. Lord, please see, my lord, so that my learned friend rest assured, page 34. Your lordships have that, my lord, my application.
the act actually.
You've got the act. Your lordships have the act, my lord. Kindly see section 2. I'll not read all sections, my lord, some of the sections. Appropriate governments, your lordship can skip. Establishment, defined. Family, defined. Inclusive education, defined. Institution, defined. Please come to 2K. Transgender person means a person whose gender does not match with the gender assigned to that person at birth and includes trans man or trans woman, within bracket, whether or not such person has undergone sex reassignment surgery or hormone therapy or laser therapy and such other therapy, bracket over, persons with intersex variations, gender queer, and person having such socio-cultural identities as so and so, so and so, so and so. Correct, my lords? Your lordship's concern freedom of choosing sexual orientation. No objection, my lord, cannot have any objection. That's my lord's judgment. Freedom of privacy. No objection. Act take care. Discrimination, there cannot be. The act takes care. I'll my lord show to your lordships. The limited question is conferment of a socio-legal status and whether that can be done by judicial adjudication, and I'll come to special marriage act. Lord, now please see prohibition against discrimination. It's not, my lord, right now nobody is arguing the question of dignity, respect, privacy, etc. Right to choose one's sexual orientation. The definition is widely worded. Any deviation from the normal sexual my lord, orientation is protected under 2K. And my lord, rights are given, and any discrimination is criminally prosecutable. Right now, the limited question is, can by a judicial adjudication process, this honorable court create a institution of marriage for the simple reason, Lord, whether we like it or not, whether they give it up or not, whether, my lord, your court would go into it or not, it necessarily affects personal laws. Lord, Hindu Marriage Act is a codified personal law. Islam has their own personal law. Part of it is not codified. Hindu law also, part of it is not.
Getting into it, Solicitor, we said
Only a minute.
to them that so far as personal laws are concerned, we are not at present getting into that arena at all.
That's not the point. Somebody who is Hindu, who is not here, can come and say that, why did you not give me the same treatment? I want to be Hindu. I want to marry under the Hindu Marriage Act. And if you give benefit...
But we are not getting into it.
We are
Why?
getting into it. So then where is
Your lordship will have to. Right now, your lordship don't have that argument.
We have
There's no compulsion. We must get
Only. Like, can I?
You don't have to decide the broader in order to decide the much more restricted arena.
Societal relations, acceptance of any relationship in the society is never dependent either on legislation or on judgments. It comes only from within. Let us accept it, whether we like to accept it or not. But leave it at that. That's, my lord, more on my lord, other philosophical aspects. Your lordships are persuaded to take up special marriage act, possibly, my lord, on the ground that in one of the section the word used is spouse. Lord, my respectful submission is this, and kindly, a person, Lord, not a spouse. My lord, my respectful submission is this, and kindly, my lord, examine this correctly, a little, my lord, closely. Even special marriage act, and I will show, my lord, if I have to, my lord, at the subsequent stage. The legislative intent of the legislature throughout has been a relationship between a biological male and a biological female, including special marriage act.
But Mr. Solicitor,
Number one,
there's a very important value judgment which you are making, that the very notion of a biological man is absolute, or that a notion of a biological woman is also an absolute notion.
Never change.
Which is incorrect.
The only biological man means biological man. It's not a question of notion.
Possibilities of rights.
Yes, of course it is.
None of us.
There is no absolute concept of a man or an absolute concept of a woman at all. That's the whole argument in a broader context.
Biological man, my lord, means man only. It means, my lord, biological man. It's
Biological man is not a definition of what your genitals are. It's far more complex. That's the point.
We stop having rights if we are not a biological.
So even when the Special Marriage Act says man and woman, the very notion of a man and a notion of a woman is not an absolute. Based on what genitals you have.
Lord, biological man means genitals you have. Lord, I didn't want to use that expression.
That's a point of view.
Lord, another thing. For man, irrespective of other attributes than the genitals, there are separate age limits prescribed. Lord, what are we doing? In Nautaj Johar, when the limited question was decriminalisation of Lord, section 3, X mentioned in 377. The central government very carefully filed an affidavit that we leave it to the wisdom of the court. We are not, but there we did say in no uncertain terms and recorded by your lordships that this is not an issue where we were even remotely touching about other issues of marriage, etc., etc. But as my lords have said, the window of marriage did open there. Now, today your lordships may not go into the question of personal laws, but the window of that personal law will open. Lord, ultimately, your lordships are dealing with us.
Solicitor, we cannot ever bind future generations after we
That's
are gone.
exactly my submission.
Kids are dusted and done.
Lord, that's
the task for the future generations.
Lord, that's for
whether it's the legislature or the court. I mean, we leave it open to
Lord, that's
future generations to run the country with the sense of
I'm not saying your lordship would bind. Your lordship would never bind. That's the majesty of the court. But your lordship's not going it right now and giving some considering giving some relief would not mean that your lordships have never gone. That would, my lord, open another. That's all okay, my lord. That's okay. But ultimately, my lord, your lordship will have to consider that this even Special Marriage Act does not prohibit. And entry 5 concurrent list is agnostic. It's not on personal law. It's a law of marriage. It's not Hindu marriage, Parsi marriage, or Muslim marriage. It's a law of marriage. It's their right to legalize, not to legalize, provide for many things, etc., etc. And therefore, my lord, again, I am reiterating that my preliminary application, and there is a reason why I am repeatedly reiterating, my preliminary objection be taken up first, and your lordships may issue notice, my lord, to all the states. I am reiterating that request with a purpose, my lord, with an intention.
All right, we'll reflect on it at lunch and we'll take a call. Certainly
Well, it's at least some of us on this side, at least for speaking for myself, believe in the autonomy of the individual. And I think people are entitled to have a relationship of whatever kind, whether it's the same sex or not, Mullas. I think that needs to be celebrated because that's the way society is moving forward. But having said that, Mullas, assuming your lordships were to say it is a valid marriage, it's fair, Mullas, your lordships can say that. Now, Mullas, supposing the marriage breaks down, they've adopted a child, what's going to happen? Who's going to be the father? Who's going to be the tenant? Under procedural criminal law, Mullas, who is the woman? Who will be maintenance? These are very, very serious societal consequences of that declaration. Either you take it as a whole or don't take it at all. I'm not averse to either. But if you do it piecemeal, it'll create more problems for that unity, for that union, for those two people, whether they're women or they're... In other legislations, when this has been done, if you look at the legislations around the world, they actually reform all the other laws in tandem with it. If you do it piecemeal, you will actually be hurting that very community. That's very dangerous. I am all for it personally, but I'm not in this fashion.
Why do you think do everything?
Either you do everything or you do nothing. But if you do it piecemeal, you're going to hurt that union.
You are representing which state? Sorry.
Well, I'm not representing anybody. In fact, I need not even argue because your lordships are leaving out personal law for Jamiat. So I need not even argue. But I'm just,
I just want to know.
An officer of the court.
I want to know which is the group you represent. Yes. If you're not representing Jamiat.
I'm sorry?
Which is the group you represent? Which is the state?
Jamiat, Jamiat Ulema E Hind. Not parties. Therefore, I am out of it, really, because your lordship has clarified it. I don't have to be here. But I want to, just as having practiced here for so many years, I need to. Yes. These are very, very complex, serious issues. If you decide it piecemeal, it's going to have huge ramifications. There'll be ghettoization. Imagine the impact in a village.
Mr. Sibal, what we can do is that
on the preamble of this constitution. My friend said, how are you equal? We became equal in 1950. Have a look at the preamble. And then, my lord, I will shortly show the discussion on the preamble in Puttuswamy in the opinion of his Lordship my Lord Justice Chandrachud. But first I will show to your Lordship my Lord the preamble. And your Lordships know, my Lord, preamble was held to be a part of the Constitution in Keshavan Bharati. It is intrinsic to the understanding of the ethos and the philosophy of the Constitution. And, my Lord, all these articles 14, 19, 15, 21 really flow, my Lord, or are adjuncts of this preamble. Kindly see, my Lord. We, the people of India, having solemnly resolved to constitute India into a sovereign, socialistic, secular, democratic republic. We are more concerned with secular in the context in which we are placed, my Lord. To secure to all citizens justice, liberty of thought, expression, belief, faith, and worship. See the articles, my Lord, which will be involved in this. Liberty of thought and expression, Article 19, Article 21 also, because the right to have dignity to live a full life. Faith and worship, religion, secular, pluralistic. It will go to Article 25, 29. Equality of status and opportunity. The implementing provision will be 14, 15 and 16, which are, my Lord, a triangle. Not the golden triangle, but a triangle between themselves. 14, 15 and 16. And then to promote among them all fraternity. So justice, liberty, equality will allow, my Lord, promotion of fraternity. Fraternity, my Lord, is brotherhood, community interest, assuring, these words are prophetic now, assuring the dignity of the individual. Now, my Lord, this dignity sits in Article 21 in terms of Puttuswamy. Dignity, an adjunct of privacy. It sits in Article 21. And the unity and integrity of the nation. This is very important. So it is not, my Lord, only dealing with these individual rights. It says that justice, liberty, equality will promote fraternity. What will it do? It will assure the dignity of the people of India or the citizens of India, give them the full panoply of rights under Article 21 and 14, 19, etc. And the unity and integrity, my Lord, unity and integrity is a far higher concept than mere individuals. So it will coalesce, my Lord.
Actually, Mr. Rohatgi, there are two words in the preamble which have not been dealt with too often, which is and to secure to all of its citizens.
Yes, yes.
The first part says to secure to all its citizens.
Correct. I'm grateful.
Secure means to enable them to have the protection of or enjoyment of these values.
Yes.
So
affirmatively.
Right, affirmatively.
Not affirmatively.
And that is individual.
Yes.
Now the latter part says and to promote among them all. That's very important.
All, my Lord.
So it goes beyond the individual.
Yes, all means the entire society, which consists, my Lord, of citizens having different views, different hues, different color, different religion, but we will treat them under one umbrella. They will form, my Lord, and forge the unity of this nation. Why was unity important? Because we had just come after a partition. So it will forge, my Lord, all people together as one unit, but having dissimilarities. And the pluralistic or secular society accepts and understands diversity, plurality, multilingual, multi-faith, multi-religion, multicultural. That was the concept. Our parents have by and large accepted us. We are outside the closet. So we have gone through the process with our parents already. who belonged to an earlier generation, to whom it was not the norm as we understand, because the closet, my lord, was not opened 50 years ago. They have accepted. They want them to settle. They want them to have a family. They want them to have the same recognition, my lord. They don't want them to be ostracized. That the children are ostracized and the parents are ostracized. Oh, you have children who are not normal. So the ostracism will reach there also. It may reach their close friends. All that, my lord, has to be wiped out. If the constitutional goal of the preamble, as reiterated by this court in Nalsa, Puttuswamy and Navtej, my lord, have to be given full effect. My lord, in my case, the first case, the ceremony was conducted by the parents, my lord, 10 years ago. So they also, my lord, went through some kind of transformation or whatever you may call it.
By more people.
Yes.
Yes.
And they had a reception on their
They had a reception.
in the town.
They had a reception. Some people, my lord, I have read, because you can't get married here, they go abroad and get married. Get a certificate from there. So there are all kinds of, my lord, situations.
Open by saying, what is this matter about? Well, it is, of course, about those three headings, which are, well, first and foremost, the interpretation of the Special Marriage Act to be interpreted what might be called constitution compliant, consistent with the Constitution. On the touchstone of, well, the larger constitutional values of Preamble and all the Part 3 relevant articles. So that is constitutional compliant interpretation. And that brings in 21, 19. The operative word is non-discriminatory or a discriminatory exclusion or achieving a non-discriminatory inclusion. That's the most important catchword in this case. That is the first head. The second head, Malits, is going to be the notice and objections regime of the same act. And the third would be, Malits, the relief, which your lordship will modulate or tailor or mold in whatever appropriate form your lordship wants.
On the second point, is there, I take it that there is a petition asking for a declaration.
Yes, our in particular, my petition.
No,
particular.
typical.
Directly, there are more also.
No,
There are
it's all
several.
right. I just
So
want.
long as there's
Absolutely.
so long as there's a
When I
fair
came for admission, my learned friend was told, well, rightly that there are other
Fair.
matters pending, but he said this is unique
All
to
right.
this point.
And what is the third point you were saying?
Third is remedies, well, how you
Remedies.
mold or tailor the remedies or achieve a result which is effective, Malits, on the ground. Before I go by these three heads, Malits, the first question I ask myself, what is this case about? And a very brief opening, Malits. My submission is, Malits, that the heart of this case is not about the statutory provision, the reading of these sections as constitution compliant or non-compliant, which are important, the notice and objection regime. The heart of this case is, Malits, the right to choose. The most enduring of all relationships, the marital relationship, regardless of sex and sexual orientation, regardless of gender or gender identity. And Malus, to manifest the idea of love in marriage, regardless of those distinctions, sex, sexual orientation, gender identity. The right to love, the right to manifest that love in the form of marriage, regardless of these identities, is the heart of this case. And the obverse heart of this case is the discriminatory denial to a section. The mirror image part of this case is the discriminatory denial to a section of the community to do it based on that sex, sexual orientation, gender or gender identity. That's the exclusion. That's the discrimination. Right? Whereas Navtej Johar was momentous by decriminalisation. But it still remains, Whereas in a real sense, little done, vast undone. And your lordship is now travelling from the little done in the journey of the vast undone. Your lordship is trying to do the significant done. There will always be, of course, things left. So your lordship is removing the next brick of discrimination and exclusion. Exclusion and discrimination is the heart of that issue. Why is it that there is one class of marriage, I will use the word traditional marriage, versus the other excluded class, non-traditional? Let's use just a neutral phrase. Reason number one, for those who seek any form of marriage, whether this side or that side, they seek it for a community and a social validation of a relationship. And I can't agree more with Mr. Tushar Mehta that just like heterosexuals seek it and deserve it, non-heterosexuals seek it and also deserve it. Number two, marriage is vital and important because of a sense of security it provides to couples. Of course, it applies much more to vulnerable couples, which your Lordship is already protecting under SMA. And this is another set of vulnerable couples this side. But it applies as a sense of security to couples generally. And why should there be an exclusion of one set of couples for that as opposed to another set? So Alan is absolutely right. It's because of the importance of the institution of marriage that we wanted to apply across the board, across this table, not that it stops in between this table. Third, it provides greater financial support, security. And not one of these, if it applies to heterosexual couples, should not travel on to the non-heterosexual class. Not one of these. Based on an ascriptive disqualification. Number four, which I must put in a chart now. I made an appendix, which you should find useful. What my Lord put as consequences. That's the fourth point. It's a gateway to those consequences. I mean, obviously, I don't marry because I want a tax benefit. I mean, some people do, but some people do. But normally, I mean, you would not be. But it is a gateway to 10 important things there.
People even separate to get tax benefit.
Yes.
What I was going to say.
That actually is more likely.
It's very common.
More likely. Or pretend to separate, as the case may be. But those gateways are tax, inheritance, adoption. Take most important, adoption. Your Lordships has in this court, well before we started talking about ascriptive cases like this, many years or decades, several colleagues of ours, who may be single persons, who have adopted. We know it, we have been in the bar. Your Lordship has been in the bar.
Incidentally, even if a couple is in a gay relationship or a lesbian relationship, one of them can still adopt.
No, more.
So the whole argument that this will create a sort of a psychological impact on the child is belied by the fact that even today, on the state of the law as it stands,
grateful.
Once you have decriminalized homosexuality,
absolutely,
therefore it's open to people to live in together, and one of you can adopt. It's just that the child loses the benefit of parenthood, so to speak, of both the
respect. If your Lordship were to look around practically on the ground, this is one of the most important reasons. Which is fifth, is that marriage by itself, or rather, Lordship, we call it marital status. Marital status is by itself, a source of dignity, fulfillment, and self-respect. These are not mere adjectives, this is a real life, real world. It does happen, it is actually happening, it is vital. And a lot of people are acting for that basis. It's a source of dignity, fulfillment, and self-respect as a core member of society. And last is, it's a integral aspect of the ability to have and enjoy a family life. To have and enjoy a family life. With the other indicia we have talked about.
Contrary to what the union has advanced in its counter and in its opposition in court, India's parliament, in India, the parliamentary form of government that we adopted as we the people when the constitution was adopted, unlike England, is a constrained parliamentary form. In England, parliament is sovereign. In India, simply put, parliament is constrained. Constrained by what? constrained by the Constitution as interpreted by whom? My lords. That is the separation of powers formula that we the people gave ourselves. So to say that this is a matter for Parliament is not just unknown to the Indian parliamentary form, which is constrained by the Constitution, but in fact seeks to impose a British parliamentary model, which has no place in this jurisdiction. So the government of India cannot come to court and say that we the people, and we may be a minority or a substantial part of this population, cannot come to court and say that this is a matter of Parliament, because our Article 32 rights, the right of judicial review, is part of the basic structure of this Constitution, of which this basic structure doctrine we have now celebrated 5 decades. Those 5 decades belong to LGBTQ people also. Marriage was a bouquet of rights. And what is that bouquet of rights? The table of benefits, my lords. Very briefly, I'll discuss that. It's part of the written submission, so I won't belabor it. But these benefits include gratuity, provident fund, and my lords, dare I say, pension of judges, including Supreme Court judges, are all premised on the understanding of one thing and one thing alone: a spousal relationship created by marriage. We are excluded from all of that. That is my table of benefits at page 35 of the written submissions. That is point 4.
The question is, how far and how much further do we have to go? This is just any other case at the end of the day. It may mean a lot for all of us personally. It may mean a lot for many other people in the community as well. But at the end of the day, my lords are discussing a list which is before my lords. Someone has challenged the provisions of the SMA and the SMA alone and no other act. My lords will therefore decide the constitutionality and mold the relief accordingly. If somebody comes with a petition of the HMA, ABC thing, the doctrine of precedent as earlier evolved, including this case, will then be applied to that case in future and say, well, the necessary implication is that yes, gratuity must also be given to you because we have so held in superior. Or it is not possible because that is the difference between parliamentary functioning and judicial decision making. Parliament has the power and the jurisdiction in one go to have a complete understanding of everything. That does not mean that when there is an infraction of fundamental rights, and I think we must remember that this case is about marriage equality. And we focus constantly on the positive aspect of Article 21, Article 21. There is a very important Article 14 right as well, saying that if heterosexual couples have the right to get married under the SMA, and if you do not include us, non-heterosexuals, within the domain of the SMA, there is a violation of Article 14.